Thank you. Was I muted that whole time? Okay. All right. So we're having some tech issues this morning, but we're back on. And so apologies to those who were waiting for us to come on, but we are opening, I'm going to open the public hearing on LD 625, which is a resolve directing a review of crucial needs and lapses in responding to and preventing sexual trauma in the Maine National Guard. And we'll recognize the bill sponsor, Representative Riley. Welcome, and you're good to go, sir.
Thank you, Senator Lucchini, and thank you, Representative Caiazzo, and fellow members of the Joint Standing Committee on Veterans and Legal Affairs. As you know, I'm Representative Morgan Riley, and I represent House District 34, which includes part of Westbrook. I'm here today to present LD 625, resolve directing a review of crucial needs and lapses in responding to and preventing sexual trauma in the Maine National Guard. This resolve directs the Adjutant General to conduct a review of the implementation of the recommendations made to this committee outlined in Resolve 2013, Chapter 66. Additionally, this legislation assists in identifying any crucial needs and lapses in responding to and preventing military sexual trauma in the Maine National Guard to determine if additional action is indeed necessary. The report compiled by the Maine National Guard in response to the resolve passed as a result of LD 1504 in the 126th legislature reported back that the Maine National Guard is currently complying with many of the 14 discussion points below, as outlined in the NDAA 2013 and subsequent policies or regulations at the national level. And in some instances, the National Guard is not able to fully comply with the proposals due to programs and policies outside of our control. However, there are several discussion points from the report that are worth relooking at that include, but are not limited to, the following. A, the mandatory administrative separation or dismissal of any members of the Maine National Guard convicted of any sexual offense. B, allowing victims to return to active duty after separation to help prosecute sex offenders. C, the creation of an independent review panel to examine the way sexual assaults are investigated, prosecuted, and adjudicated under the Maine Code of Military Justice. D, the annual command climate assessment surveys, along with the required sexual assault prevention and intervention in pre-command and command courses for officers and relevant personnel. According to the Department of Defense fiscal year 2019 annual report on sexual assault in the military, sexual assault reports among service members increased by 3% compared to fiscal year 2018. In fiscal year 2019, 6,236 reports were made, up from 6,053 the year prior. The department is unsure if this increase is due to an increase in reporting or incidents, but there are measurements in place to regularly assess the efficacy of their efforts to reduce sexual trauma among service members. I commend the Maine National Guard Sexual Assault Prevention and Response Program for their work in reducing and addressing sexual trauma. The National Guard has made their commitment to eliminating incidents of sexual assault and trauma through awareness and prevention training clear. However, I believe that continued examination of response and prevention services is necessary to ensure the safety of those who continue to devote their lives to serve our state and our nation. Thank you very much for your time and consideration. I'd be happy to answer any questions or to provide you with any information for the upcoming work session.
Great. Thank you, Representative Riley. Any questions from the committee at this time? Okay, seeing none, thank you for presenting the bill. Okay, so are there any co-sponsors who wish to testify? If so, if you're in the attendees list, just raise your hand. Not seeing any, so we will next recognize Scott Young from DVM, and he'll be followed by Elizabeth Ward-Saxel. Welcome, General Young.
Good morning. Would you like me to testify?
Yeah, you're up. You can go for it. Yeah, sorry.
Great. Thank you. Well, good morning, Senator Lucchini, Representative Chiazzo, and members of the Joint Standing Committee on Veterans and Legal Affairs. My name is Scott Young, and I'm the Deputy Commissioner of the Department of Defense, Veterans and Emergency Management. I'm here today to testify in support of LD 625, a resolve directing a review of crucial needs and lapses in response to preventing sexual trauma in the Maine National Guard. The Department of Defense, Veterans and Emergency Management is committed to preventing sexual violence in the Maine National Guard. Since the Resolve 2013 Chapter 66 report was completed, our program has grown considerably on the federal side, and we have continued to work diligently to address all updates and changes as they come in. We have a robust program. However, the 54 states and territories are all unique, and we are working continuously to refine our program to meet the unique needs of Maine victims. Should the resolve pass, we will graciously review and report back on the status of implementation of the recommendations made in our previous report to your committee. We also look forward to the opportunity to working with the committee relative to needs and gaps, which may require legislation. Thank you for the opportunity to speak on this important subject. In the Maine National Guard, our people are our most valuable resource. I'll answer any questions you may have, or I or members of our staff will be available for work sessions on this bill. Thank you.
Great. Thank you, General Young. Any questions from the committee at this time? Seeing none, thank you for your testimony, and I'm sure we'll see you at the work session.
Certainly.
Great. Thank you. Okay, next on our list is Elizabeth Ward Saxel. Welcome. Floor is yours.
Good morning, Senator Lucchini, Representative Chiazzo, and members of the Committee on Veterans and Legal Affairs. My name is Elizabeth Ward Saxel. I'm a resident of Belgrade, but today I'm offering testimony on behalf of the Maine Coalition Against Sexual Assault. I know some of you, and I know some of you know about MICASA, but for those who don't, we represent and serve Maine's sexual assault support centers and Maine's children's advocacy centers. MICASA initiates and advocates for victim-centered public policy, provides expert training, technical assistance, and resources for providers and partners, as well as being the funder of the victim service providers in your communities. MICASA is here today in support of LD 625, and thank you to Representative Riley for introducing it. According to Muskie's Crime Victimization Survey, 1 in 5 Mainers will experience sexual assault at some point in their lifetime. And each year, 14,000 Mainers will experience sexual violence. Unfortunately, we know that sexual violence occurs in all of our communities and within institutions like the National Guard. We also observe that institutions, from colleges to churches to our military, are prone to protecting themselves, sometimes at the expense of victims of sexual violence. As a result, it's critical that our institutions are intentional about regularly examining the ways that individuals are at risk of and are experiencing sexual violence, and what additional actions should be taken to prevent and better respond to victimization. We are grateful for the National Guard's support of this bill, and also just want to shout out for Maine's National Guard SARCs, the Sexual Assault Response Coordinators, who are just absolutely awesome. We work with them all the time, and every day they're working to support Mainers who are part of the National Guard. We'd be pleased to assist with this work in any way we possibly can, and I'd be happy to answer any questions you might have. Thank you for having me.
Great. Thank you for your testimony. Any questions from committee members at this time? Seeing none, thank you. Okay, and that concludes the list of people who have registered to testify. And seeing nobody else in the attendees list, I will close the public hearing on LD 625. Okay, the next bill that we'll take up on our list, we're going to move to LD 693, an act to make the pilot program providing mental health case management services to veterans a permanent program. And we'll recognize the bill sponsor, Representative Roberts, to present it. Welcome.
Good morning. Good morning, Senator Lucchini, Representative Chiazzo, and distinguished members of the Joint Standing Committee on Veterans and Legal Affairs. I am Representative Tiffany Roberts, and I represent House District 6, which is comprised of the majority of both North Berwick and South Berwick. I am here today to present LD 693, an act to make the pilot program providing mental health case management services to veterans a permanent program. During the 128th legislature, LD 1231, a resolve to examine the need for mental health care services and establish a pilot program to provide case management services to veterans, was passed into law. I believe that Congressman Golden has provided written testimony available for you online in regard to this. In the 129th legislature, I sponsored LD 835, which was legislation that would have provided support to this program. Although this legislation passed out of this committee, it died upon conclusion of the legislature due to the COVID-19 pandemic. The legislation before you today, LD 693, makes permanent the pilot program established in LD 1231 to provide ongoing mental health case management services to veterans after the pilot program ends. The emergency clause in this legislation is to ensure that the funding for this program does not lapse. I believe it's due to lapse at the end of June right now. Each month, the Bureau of Veteran Services assists veterans in submitting hundreds of claims for numerous programs and is successful in securing millions of dollars in awards for veterans and their families. According to the Maine Office of Substance Abuse and Mental Health Services, these types of services provided in this program helps keep veterans from languishing on wait lists for services for which they are eligible, and that case management services are more cost-effective than inpatient psychiatric care. It is important that this work continues to support those who provide such an enormous service to our country. I grew up in a military family with both parents and step-parents serving in various branches. I am keenly aware of the sacrifices our veterans make, and it is my experience that, in many cases, veterans tend to have a mindset they need to handle situations on their own. When veterans do ask for help, that window of time to provide assistance can be very short. Help must be provided as quickly as possible, and the offer for help must be ongoing and readily available. I thank you very much for your time and consideration. I would be happy to answer any questions or provide you with any information for the upcoming work session. There was a report back to this committee last session on this program. I'm not sure Director Richmond's on have it, but I'm sure we can provide that for you for the work session as well.
Thank you, Representative Roberts. And just for committee members' reference, our analyst has sent over that report this morning. So if you look for an email from Janet, it will have the report from last year. And those on the committee will likely remember we had Director Richmond and Dr. Pollard present last session. So Representative Dolph.
Thank you, Mr. Chair. Representative Roberts, I see there isn't a fiscal note attached yet, but do you know what this is costing us?
I know that
will
right
you
now,
have fiscal note ready?
I believe Molly Bogart may be able to answer that better for you. Right now it's being funded by DHHS. They picked it up because the program would have lapsed when we adjourned last session because the previous legislation didn't make it through. So DHHS picked up where they had left off. So she might have a better idea of what that is.
Thank you.
Representative McCray.
Thank you, Mr. Chair. Thank you, Representative Roberts. I remember very well the testimony and the presentation from last session. Was incredibly impressed by the program. Is it fair? I'm reiterating what you said, I think. Is it fair to say that the cost of this program prevents much greater costs down the line because we can prevent sequelae from happening?
Oh, absolutely. We're talking about salaries of, a handful of case managers versus what could be inpatient psychiatric treatment or worse.
Any other questions for the bill's sponsor? Okay, seeing none. Thank you for your, Representative Corey. Yep.
Thank you, Mr. Chair. Not having been on this committee the last time around and not being familiar with this bill, and I'll do everything I can to get myself up to speed. You say that there was a pilot program and then this would make that pilot program permanent. Who was that pilot program evaluated by? Was it through the Veterans Administration, or was it through Health and Human Services? Was it a sort of a combination? Do you have information sort of on that pilot program itself? Was there kind of like an evaluation report?
Yes, I believe that's the report back that Senator Lucchini was referencing that was sent out to you.
Okay, great. Thank you.
Yep, it was a joint effort to also, so it's in your email, and we can have kind of a presentation for the work session too, if that'd be helpful for members.
Probably. Thank you.
Yep, sure. Senator Farron.
Yeah, I think that probably would be helpful for some of the folks that aren't familiar with the history of the program. This is one of those ones that goes back to the 128th, I believe, with the pilot program and Congressman Golden and a bunch of other folks. And it really was kind of remarkable to see at the time the commissioner of DHHS, the American Legion, the VLA, the legislature as a whole come forward on this. And I think it's, well, we talked earlier, and I think Representative Corey mentioned about we as a committee picking our battles about what we got to fight for through this funding situation. I think this is one that we ought to keep our eye on and kind of keep it in our back pocket of what's important and what we have. And I think you're going to hear that testimony with the Legion, some of the VSOs and some of the other folks. So that report back would be very helpful, Senator.
Great. Yeah. Thank you, Senator. And working with our analysts, we'll try to schedule a presentation from either the DVM and HHS or whoever will be able to make it from them. It is really a compelling project. Representative Wood.
Thank you, Mr. Chair. I just wanted to point out, I know it was said that Janet emailed us a copy of the report, but I want to thank Janet because she's also putting all those kinds of things now in that new, I don't know what to call it, system where we have all the testifiers, and that report's right in there. So we can take a look at it there also, but I would also appreciate a presentation on that. It's a little bit of a lengthy report. Thank you.
Any other?
Janet.
Yeah. Any other questions this time? Seeing none, thank you, Representative Roberts, for your testimony. Okay, so next up, we will recognize from DVM, we'll bring in Dave Richmond from the Bureau of Veteran Services, and he'll be followed by Molly Bogart from HHS. So welcome, Director Richmond. The floor is yours, sir.
Good morning. Thank you. Good morning, Senator Lucchini, Representative Chiazzo, and honorable members of the Veterans and Legal Affairs Committee. My name is David Richmond, and I'm the Director of the Maine Bureau of Veteran Services. I'm here today to testify in support of LD 693. As Bureau Director, I've come before you on several occasions to discuss issues that directly affect the lives of Maine veterans. One of the most urgent issues facing our veteran population is mental health care. Whether due to negative experiences or events that may have occurred while in service, or the current pandemic that has forced isolation for so many. Mental health care is critically important to the lives of those who served, and the need for improved access to high quality care is vital. On January 1st, 2018, Maine hospitals began implementing a pilot program to identify veterans in need of mental health and behavioral health care. The Department of Health and Human Services, in coordination with the Maine Bureau of Veteran Services, entered into contracts with both Easter Seals of Maine and Health Affiliates of Maine in an effort to ensure a statewide network of case management was established, which provided coordinated mental health care services to Maine veterans. The pilot was deemed a success as veterans were presenting to the ERs across the state and were then provided connection to case management at either Easter Seals or HAM. The pilot was open to all veterans free of charge, no matter their discharge or length of service. And the term veteran included any person who had served in the United States Armed Forces, active duty, National Guard, or reserves, and who needed mental health treatment or mental health navigation. Any service member currently serving in the Armed Forces was also eligible. Both Easter Seals of Maine and Health Affiliates of Maine were selected to serve as participating providers due to their history of working with service members, veterans, and their families. These resources are tremendously valuable assets to our veterans population. I thank you for taking the time to hear testimony on this important topic, and I'd be happy to answer any questions that you may have at this time. Thank you.
Thank you, Director Richmond, and thank you for your work in administering this program. If possible, would you and HHS be able to come kind of give us a briefing on the report at some point, working with our analysts, and find a time that works?
I'd be happy to. I did reach out to DHHS, and I believe they're going to have somebody available for the work session. And I'll be there also.
Great, thanks. Any questions from the committee? And actually, I have one more. I think in your presentation, after we had implemented this I'm thinking from last year, hasn't this kind of become a model that other states are now following as a way to provide these services?
I know a lot of states are looking for ways to expand their capacity in the communities. So there's all different types of solutions through our counterparts in the other states. I'm not aware of a particular state that's using this model.
Okay. Great. Any other questions? Seeing none, thank you for your testimony, Director.
Thank you.
Great. So next up, we have Molly Bogart from DHHS. Welcome.
Good morning. Thank you, Senator Lucchini, Representative Chiazzo, and members of the committee. My name is Molly Bogart, and I'm the Director of Government Relations for DHHS. I believe it's the first time I've been before many of you, so I'll take this opportunity to invite you to reach out to me with anything that, any questions, concerns you have for DHHS across the board. But today, I'm here just to bring your attention to a letter from Director Pollard of the Office of Behavioral Health, formerly the Office of Substance Abuse and Mental Health Services, or SAMS, in support of the bill. We are, and ignore my cat, I apologize. We are, I won't repeat all that Representative Roberts and Director Richmond shared with you, but broadly, we find this program to be incredibly successful. We know that it helps keep veterans from languishing on wait lists for services and helps them receive case management services, which, as you've heard, are much more cost effective and better for people's quality of life and quality of care than inpatient services, and helps strengthen our mental health, community mental health safety net. And so, Dr. Pollard will certainly be available for the work session. In the report that we did provide to you last year, there is some information on the cost of the service. We are currently planning to continue this program, and passing this bill would be certainly a help to that. We right now have an RFP out to expand this to a third service region, and hope that you will join us in supporting our veterans through this successful programming. And happy to answer any questions I can, or more likely return with some answers at the work session.
Great, thank you. Ms. Bogart, and thank you to HHS for continuing to fund this even after the money dried out last year. So it's been great to see that the project has continued. So Representative Supika.
Thank you, Senator, and good morning, Ms. Bogart. I was wondering if you could, for me, just expand upon, like, they've been touched upon, but kind of explain a bit about how it is cost effective versus inpatient, and kind of, so I kind of have an idea of what it is that you mean when you say that.
Sure, and this is something that Dr. Pollard can certainly speak to more effectively than I can, but essentially when we're able to do that early intervention and case management to help folks get housing services that keep them stabilized, or community mental health services that keep them stabilized, or get them stabilized, it allows us, the state, to provide that service instead of paying for inpatient mental health service, which is very expensive and generally not, not a long-term solution, not the best type of care if you can get that early intervention. And so it allows us to spend money at the community level, which is lower cost, and hopefully provide some more longer-term stability than investing in that acute, in acute mental health crises when people are required to be inpatient. It's not an alternative when people need that inpatient service, for sure. But if we can avoid that inpatient care, oftentimes that community care is both less effective, less expensive, and more cost effective.
Thank you. So, like, it's important to fund those services to try to avoid them, not gotcha.
Exactly. Yeah, it's not an alternative if inpatient is required. It's just, if we fund those, we can often avoid that inpatient care.
Okay.
Which can be more expensive.
Thank you so much.
Yeah.
Great. Any other questions from the committee at this time? Representative Corey.
Thank you, Mr. Chair. Thank you for being here today, Molly. Just to clarify on that, like, I imagine that if somebody does have inpatient care, they're probably going to require outpatient care after that as well, and additional services, correct? It's not that, if somebody has to go have inpatient care, they come out without, needing any additional services, correct? They'll continue to need services.
I think that is most likely the case. Each person has individualized needs, but I would say it was probably infrequent that somebody needs inpatient care and then does not need any community support when they leave.
Any further questions? All right, seeing none, thank you for your testimony, Molly. Okay, next up on our list, we'll go to the neither for nor against category, and we'll bring in Jeff Austin from the Hospitals Association.
Good morning,
Welcome,
Senator
Jeff.
Lucchini,
Yeah.
Representative Caiazzo, members of the committee. My name is Jeff Austin. I'm here on behalf of the Maine Hospital Association. I don't see this committee very often. We represent the 36 private hospitals in the state of Maine. There are 2 public hospitals that the state operates, the 2 psychiatric facilities. We do not represent them. Our testimony is neither for nor against. We have no position on the continued operation of the program, which is Section 2 of the bill. It appears to be successful and widely supported. Our questions are about Section 1, which is the data collection element. The original bill sunsetted the data collection piece. I'm not sure that ongoing data collection is necessary for the successful operation of this program. Obviously, we're open to being convinced otherwise. I have provided you written testimony. I had not seen the report before. Your analyst graciously sent it over. I think the data is going to be fairly consistent, and it looks like it has been fairly consistent in every 6-month period. The report does not have the 2020 data in it. You may ask for that. If you get a update from the state agencies, you may ask them to update the table that's in that report with 2020 data. So none of the proponents who've testified so far have pointed to the data collection element as being necessary. So again, we're open to being convinced otherwise. Lots of bills come out every year looking for data. Data is an important part of public policy making, and we want to be supportive where we can. But if this can be sunset and the program can continue on without it, that would be great. With that, I'd be happy to take any questions.
Great, thank you, Mr. Austin. Any questions from committee members at this time? Chairman Chiazzo.
Thank you, Mr. Chair. Thank you, Mr. Austin, for that testimony. Is the reason for not wanting to collect the data, is it cumbersome? Is it costly? Is it not data that's already readily available? What's the concern with acquiring and processing the data?
Well, obviously, two things. The question can be presented from any perspective. Our perspective is, what is the need for the data? If it's necessary, we'll continue on. If it's not, then we would ask to discontinue it. The costliness is not really the issue. If you look back at the original legislation, Representative Golden graciously fought, and the legislature provided funding sort of for one-time costs to alter our electronic intake systems, because we had to add a field to the record that didn't previously exist, and that required some programming. But that was a one-time cost. I think the issue is, and those of you who have been through a hospital emergency room, you're hit with a lot of bureaucracy in addition to medicine. And if we can keep those bureaucracies down, the number of questions we ask, people hit back and go, well, why are you asking me about my veteran status? What does that matter? And you get into a whole conversation. So it's more the intake process where we're asking you for insurance, we're asking you for medical background, we're asking you for surrogate decision makers if necessary. There's a lot of conversation that goes on. And so if this element of the conversation is necessary, again, we're open to continuing it. But if it's not, we'd be happy to take it out. There's literally, I think, 3 other bills looking for data collection in emergency rooms right now in the State House, and we just want to be as efficient as possible.
Okay, thank you.
Thanks. Any other questions from the committee?
To your other point, because this bill did not come out of the committee this way the last time. The original bill that created this program was a vastly different piece of legislation, and most of the work happened after the original bill was filed. The reason we were brought in to begin with is much of this data can be discovered through the main health data organization. For those of you who don't know, we have a big healthcare database. And one of the data points that they collect is source of insurance. So to the extent the veteran is covered by a readily identifiable veterans coverage, like TRICARE, then you can identify these folks without talking to us. The reason they wanted to do this was there are some folks who are not covered by an obviously military insurance product. They're covered by Anthem or something. And so you needed us to collect this data. I have no idea whether we actually captured very many people you couldn't otherwise capture just by looking at their insurance status. You may be able to capture this data. I've never seen a crosswalk between the data we collected and what MHDO already has. So you may be able to get 85, 90%, I'm making up that number, of these folks through that existing database.
Great. Thank you. Further questions? Representative McCray.
Thank you, Mr. Chair. Just for the work session, can we ask for some feedback from the department about what they feel about the data, the questions that Mr. Austin's raising?
Yeah, we'll have the department give a full presentation on the report, and we can ask questions then as well. Anything else? Seeing none, thank you, Mr. Austin.
Thank you for taking my testimony.
Yep. Is there, let's see. So we have nobody else registered to vote or to testify on this bill. So we will close the public hearing on LD 693. Okay, so next up on our list, we have LD 656, an act to strengthen the integrity of the Office of Marijuana Policy. We'll bring in the bill's sponsor, which is Representative Collings. So welcome, Representative.
Oh, good morning. Can you hear me, Senator?
Yep, we can hear you.
Okay. And are we doing 656 or 664?
LD 656, an act to strengthen the integrity of the Office of Marijuana Policy.
Okay, thank you.
Sorry, the sound drops out when we bring people up. I always forget that, so.
All right.
Yeah.
Thank you, Senator Lucchini, Representative Caiazzo, distinguished members of the Veterans and Legal Affairs Committee. I'm Representative Benjamin Collings, representing part of the city of Portland. And I have two bills with you today. The first one being LD 656, an act to strengthen the integrity of the Office of Marijuana Policy. And the basic intent behind this is very straightforward. What I'm looking to do here is to sort of kind of conform to what already exists for legislators and have that be applicable. To sorry, I have a puppy that might be making noise in the background. So yeah, currently legislators, once they are no longer in office, whether they're termed out or for other reasons don't make it back, they have a 2-year period, a cooling off period, where they're not allowed to be lobbyists, direct lobbyists to the legislature. And I believe that this should also apply to people that work for the state. And you'll hear some people after me discuss some past issues of people that worked for the Office of Marijuana Policy that later left and worked for corporate firms that lobbied the legislature. So I believe just like legislators, staff members that have knowledge and access and know how the system works, whether it's actual or perceived, we don't want to have even the supposition that there's any conflict at all that exists. So it's really that simple. I believe staff members should be held to the same standard as legislators. Some people ask me, should this apply to any government employee? And I don't want to complicate the bill. I certainly think it should apply to any state employee, that like a legislator, once you leave, there shouldn't be a revolving door where you go and work for a corporation or a lobbying firm directly, trying to impact legislators. So that's the straightforward impetus of the bill. I don't believe there's any wrongdoing when legislators or staff members leave and later become lobbyists, but I think we should be held to a high standard. And even the perception that somehow someone that the regulator working with the regulated all of a sudden switches roles, and there's a higher level of access and engagement that any other small business or member of the public wouldn't be able to do. So it's just basically making a more level playing field. I'd be happy to answer any questions. Others that I believe will testify after me will probably go into greater depth about why they believe this is needed for this specific office. Thank you for your time and be happy to answer any questions.
Thank you, Representative Collings. Representative Corey.
Thank you, Mr. Chair. So I actually was having this conversation with somebody this morning, while coming in, this idea of sort of a revolving door. And we also see revolving doors within government itself. So, oftentimes I think we've all experienced legislators going to work for administrations or for, departments within state government, or even some of our staff members that will, move from, our partisan staff members that will move from, our offices into, either other offices in state government, whether that's, a constitutional officer or, working for a governor or, potentially going to a department. Why didn't you expand this bill to all of these other scenarios that you were talking about earlier, just focused on OMP?
Thank you for the question, Representative Corey. So the simple answer is I was made aware of some issues specifically in this office. So I tried to address that, but you're right. As soon as I brought this forward, people were like, yeah, this is a good idea. It should happen, but it should happen everywhere. And I'm not for that, but I don't want to make things too complicated here unless that's something the committee wants to take on in a larger comprehensive package. I wouldn't want to, push this away and not have anything be addressed while trying to do some grander proposal. But I think it's a valid point, and I do agree with you, Representative, that as a legislator, any staff member for the legislature, executive, different bureaucracies, quasi-governmental entities, if you work somewhere and you have the connections and the relationships and you know how something works, and a large corporation hires you to immediately try to take advantage of that relationship and knowledge, I'm not saying that anything illegal is going on, but there's the issue of access, and there's an issue of not really being a fair level playing field where people that aren't in those positions, aren't probably getting the same, kind of foot in the door. So.
Yeah, no, I understand why we're seeing this bill. I think that if we were expanding it to those other areas, it wouldn't even be in the jurisdiction of this committee. I imagine it would be over at state and local or something like that. Anyways, thank you, Mr. Collins.
Thank you.
Any further questions from the committee at this time? Seeing none, thank you, Representative Collins, for your testimony.
Thank you.
Okay, so we'll go to the list of people who have signed up in advance. So we'll begin with Arlie Kraus, followed by Mark Barnett and Jared Bornstein. So Arlie, you have the floor. Welcome.
Good morning. Can you see me okay?
Yep, we can see and hear you well. Yep.
Great. Good morning. Senator Lucchini, Representative Caiazzo, and members of the Committee on Veterans and Legal Affairs. My name is Arlie Kraus. I'm a registered cannabis caregiver, farmer, and business owner in Warren. I'm a founding member of the Maine Craft Cannabis Association. I'm a member of Seed to Health Learning Health Alliance. And I am the chair of the Adult and Medical Marijuana Committee for the town of Warren, where I live. I'm testifying in support of LD 656, an act to strengthen the integrity of the Office of Marijuana Policy. While it is certainly not unusual for private companies to hire former state employees, there are inherent ethical issues which are associated with such a move. So much so that there is a 2-year ban on switching sides from government to private sector at the federal level for employees. The importance of such a ban is for the protection of small businesses from the influences of lobbyists and other entities for corporate interest. This bill would add a level of protection to an industry which already has the wolf at its door in the form of billion-dollar corporate interests coming into Maine. We should not allow corporate entities to have this level of power and inside knowledge to use for their advantage. I ask you to vote ought not to pass for this bill. Thank you for allowing me this time to share my opinion.
Great, thank you, Ms. Kraus. Any questions from the committee at this time? Representative Corey, yep.
Thank you. Was she testifying for or against? She just asked us to.
In support.
In support. Yep. Did she tell us to vote ought not to pass at the end of her testimony, though, or?
Ought to pass.
Okay, thank you.
That's okay.
Okay, no problem. I just wanted to be clear on where you were at. Thank you.
You're welcome.
Any other questions? Seeing none, thank you for your testimony, Ms. Kraus.
Thank you.
Okay, next up we have Mark Barnett, followed by Jared Bornstein, and he'll be followed by Dawson Julia.
Good morning. And thank you, Chair Lucchini, Chair Chiazzo, and the members of the VLA committee for the opportunity to speak today. My name is Mark Barnett. I'm a resident of Auburn, registered caregiver, owner of Higher Grounds, a caregiver store in Portland, Maine. Also the executive chair of the Maine Craft Cannabis Association. I'm testifying today also in support of LD 656, an act to strengthen the integrity of the Office of Marijuana Policy. For anybody following this industry in this state and elsewhere, the need for formal rules governing the commercial behavior of public officials after they leave office seems extremely clear. Two of the previous directors of Maine's medical use of marijuana program left that post to take lucrative jobs with companies that had lobbied extensively to craft regulation protecting their interests while those directors were supposedly serving the public. One of them gave us a corrupt dispensary licensing process, locking in the 8 monopoly license holders as their parting gift, sowing the seeds for the conflicts between those license holders and Maine's many small caregivers that has caused so much unproductive acrimony and made collective progress so difficult. Across the country, more and more stories are emerging like this about the confluence between potential public sector corruption and private sector greed. And it really defines how marijuana regulation in many places has been crafted. What LD 656 does for public officials working in cannabis regulation, I believe, is standard practice with federal lobbying rules. It's by no means an extraordinary policy. I do believe, however, it's an extraordinarily good idea, especially if we're concerned with ensuring the government represents the people who elected it and who supported the elected officials who appointed other public officials. So we call on this committee and this legislature to vote off to pass and ensure that we as a state are at least doing what we can to prevent the corruption that seems so endemic to this industry. Thanks very much for the time today.
Thank you, Mr. Barnett. Any questions from the committee at this time? Seeing none, thank you for your testimony.
Thanks.
Okay, next up, we will go to Jared Bornstein, followed by Dawson Julia, and he'll be followed by, it's moving around, there we go. Samantha Brown. Welcome, Jared.
Thank you, Senator Lucchini. Good morning, Senator Lucchini, Representative Chiazzo, and esteemed members of the Veterans and Legal Affairs Committee. I'm here today representing the Maine Cannabis Coalition in strong support of LD 656, an act to strengthen the integrity of the Office of Marijuana Policy. This is a good government bill. It is another version of an idea that those in public service should be working for the people, not laying the groundwork for a windfall position after their time is up in government. We have seen this idea gain traction nationally, which has been in some ways egged on by Maine. A very similar bill was proposed and later enacted by the Honorable Justin Chenette banned legislators from being a registered lobbyist for a set amount of time after their exit from the legislature. This bill does the same thing. It restricts OMP staff from leaving their position at OMP and taking a position lobbying their recent former coworkers. When government officials leave their roles, they may clean out their desk, but often the most valuable aspects of their role they keep, their relationships and influence. This gives those willing to pay top dollar an extreme unfair advantage. It also creates a perverse incentive while the officials are working at OMP to show favoritism to those who they believe will give them a position when they exit government. The legislature has set precedent by passing Honorable Chenette's bill to protect Maine's government from potential corruption. It can uphold that precedent by passing LD 656. Interestingly, in the realms of cannabis, many pains have been taken to ensure that corruption in the form of diverting products into the illicit markets. This bill is an important first step to safeguarding this budding industry from potential corruption in the future at the highest levels of state government. Closing this loophole, as the Honorable Chenette's bill did, before it opens up is something that we can do here today. Vote to support good government. Pass LD 656.
Thank you. Any questions from the committee at this time? Seeing none, thank you for your testimony. So next up, we have Dawson Julia, and he'll be followed by Samantha Brown. Welcome, Dawson. Oh, Mr. Julia, you're muted at the moment. Yep. There you
Got
go.
it. Thank you.
Yeah.
Yes, and thank you for having me today, Senator Lucchini and the VLA members. I'm the director. My name is Dawson Julia, and I'm the director of the Maine Cannabis Coalition. And this is a bill that we wrote and asked Representative Ben Collins if he would submit for us. We're very proud of this bill. And I'd like to tell you a little history about why this bill is so necessary and where the idea came from. In 2010, our medical marijuana program was initiated. And there was a lady that was the director of the licensing and regulatory services, and she was in charge of grading all the applications. There was only 8 medical marijuana dispensary licenses that were issued in Maine. And she graded, and what ended up happening, 7 out of 8 out-of-state companies or interests ended up being awarded 7 out of those 8 licenses. Shortly after that, a lot of people were upset. A lot of Maine citizens were making complaints and stuff. There was an internal review or investigation that went on in that Department of Licensing and Regulatory. And the lady who was the director of that ended up resigning, and we never saw the end results of what that investigation overturned. 4 of the licenses that she issued were issued to a company named Wellness Connection. And when she left the employment with the state of Maine, she immediately went to Wellness Connection, where she served in a high-paying position, and she also served on their board. And so that happened in 2013. And you can Google this information, and you can read all about it. The newspaper articles are still there. You would have to Google the name Catherine Cobb is the name. Now, further on after that, Catherine was replaced by a lady named Marietta, and I can't pronounce her last name properly. She was appointed to the new director of the Maine Medical Marijuana Program. During this period of from 2013, I believe, to 2016, she served. My business got harassed, like outright harassed. We had the police show up. We had the sheriff's department showed up. All kinds of police showed up. They surrounded our building. They came in to do an inspection that Marietta brought all these law enforcement officials with them. She paid the law enforcement with money that was from the department. And what ended up happening was my business, I ended up being okay. I had to file a lot of complaints, but in the long run, what ended up happening is she got let go because of misappropriations of funds for hiring those officers, and she left the department shortly after that. Within a couple of weeks, she was working for a company called Curaleaf, which is located in Maine. They're worth $11.5 billion. She was the second director. The last 2 directors we've had have left our employment and gone directly to work for the biggest, most inappropriate companies, behaving in a very bad way for the small businesses of Maine. So that's
sorry,
I know I'm out of time. I apologize. Yeah. I just want to finish that.
Okay, gotcha. Thanks. Any questions from the committee at this time? Seeing none, thank you, Mr. Julia.
Oh, thank you.
Okay, next up on the list, we have Samantha Brown. She'll be followed by Jennifer Bergeron and Dennis Meehan. So welcome.
Good morning, respective members of the VLA committee. My name is Samantha Brown from South Berwick. I testify in support of LD 656. I testify as a parent with a 9-year-old child who has used cannabis for medicine for 7 years for her catastrophic seizures. Over these 7 years, we have spent many hours at the State House fighting for patient rights and better access. Consistently, year after year, us patients, together with small givers, have struggled to fight everything that the department has thrown at us. It's always been a battle between big corporations and small caregivers and patients. Many patients, including children, rely heavily on these small caregivers. What affects caregivers in turn affects patients also. Last year, I was part of a stakeholders meeting with other patients, caregivers, and the department to find some common ground in the proposed department bill. It was clear the intentions inside the meeting was a bargaining chip. The department and lobbyists would try and meet the rest of us in the middle if we had agreed on allowing profits for out-of-state residents. When we tried to put that requirement aside, the meeting fell apart and the department wouldn't budge. During the original setup of the Maine medical marijuana program, the director who oversaw the medical program of the dispensary licensing issued half of the licenses to Wellness Connection and then later resigned to join their board. With the experience of the past and watching what's happened in other states, the intentions of the department rule change and who is writing them is pretty clear. Those on the board of the OMP are lobbyists of large corporations. I'm told there are 2 open seats in which cannabis community members still cannot sit. The medical program is unlikely to survive the rule changes. Many caregivers were fooled because of the special interests of those on the OMP. I conclude that I support to strengthen the integrity of the Office of Marijuana Policy and ways to prevent corruption that works against small businesses and patients' interests. And thank you for your time.
Thank you, Ms. Brown. Any questions from committee members at this time? Representative Corey.
Thank you, Mr. Chair. Thank you for being here, Ms. Brown. Do you have any thoughts about members of the lobby sitting on the Maine Marijuana Advisory Commission? We have one person that's supposed to be a representative of the medical marijuana industry, but really kind of, in my experience, is that the industry is kind of tribal, meaning that, you know, we have dispensaries and we have caregivers, so it's kind of hard for one person to be focused on both groups. We also have a representative of the adult use marijuana industry, but that can also look, you know, very different.
That's a good question, and I don't really know if I have an answer for that.
Thank you. Yeah, thank you, Ms. Brown. And I think there may be other bills that at least talk about that at some point. I'm not positive, but any other questions for Ms. Brown? Seeing none, thank you for coming and testifying.
Thank you.
Okay, next up we have Dennis Meehan. I don't see Jennifer Bergeron in the room yet. After Mr. Meehan, we will go to, we've had some late signups that will allow to testify, which would be Grant Ellis. So welcome, Mr. Meehan.
Good morning. Can you see and hear me?
Yep, you're good.
Great, thank you. Thank you all for an opportunity to speak and for your work in this particular area. These days like these, where citizens actually come out with good policy that supports the needs of our neighbors, our brothers and sisters, are key in our evolution as a state, as a community, as families. And I just want to honor and send some my appreciation for the people that spoke before me. Our families need more of this in our day-to-day policy within government, because our system is so broken because of exactly what this bill addresses. So I think it was Mr. Julia that mentioned what happened in the beginning of our medical program and how that really staggered our ability to reach our neighbors. That exact same thing is currently going on with this adult use program, and it's being manipulated. It's being strangled, similar to our family members that turn to cannabis as a last resort. And for so many of us to be here today, where we continually have to plead for the lives of our family members, like my father, who almost died yesterday with leukemia. See, this is a very, very real topic, and it's about more than the revenue that it brings to the state of Maine. It's about us as individuals. It's about us as families. I keep saying this every single time. And there are so few people that actually take the time to ask the experts in this industry the questions required in order to create a system that supports the entire state. And that is bothersome. Lobbyists are always asked questions, always. I would like it if some lawmakers or members of this committee would ask me questions about my family, specific questions about how the current situation is affecting my family or how it has affected our business. I am a medical marijuana caregiver, and my wife is also. We have a family business and we run it as a family. I see so many people every day that are completely fed up with the way things are run up there at the Capitol. And they talk about actually firing lawmakers.
Mr. Meehan, I'll just point out your time has expired, but if you can wrap up your testimony, that would be great.
Okay, thank you.
Very quickly, yep.
I just wanted to say thank you to everyone for an opportunity to work in the right direction for once.
Thank you. Questions from the committee at this time? Seeing none, thank you for your testimony, Mr. Meehan.
Thanks.
Okay, next up we have Grant Ellis. We'll have him followed by Jennifer Bergeron. And I believe Derek Short will be after that. So welcome, Mr. Ellis.
Thank you, Mr. Chair, for the accommodation on the late sign up. I got confused. There were 2 hearings today, and I'm very grateful for the opportunity to testify. My name is Grant Ellis. I'm a disabled and homebound medical cannabis patient. I currently live in Massachusetts, but I have family in Maine. And during my recovery, after I first fell disabled, I spent an extended period of time in Maine where I was able to utilize the services of a medical cannabis caregiver, which helped me to transition off prescribed narcotic medication. And that transition probably saved my life. So the reason I'm testifying today in support of LD 656 is very rarely is there an opportunity to actively witness a bill that can thwart regulatory capture make its way through a modern legislature. And I really applaud the committee and the legislature in Maine for taking up this bill. One of the themes that I've seen throughout Massachusetts as a medical patient, my time in Massachusetts, and throughout my time in Maine as a medical patient, is that absent guardrails to ward off the influence of corporate actors in the regulatory oversight of medical and adult use cannabis, there will be forces who, much like every other example in history, whether it be the railroads in the 1800s or otherwise, will attempt to centralize control over that regulatory apparatus and utilize that control in those relationships to buttress their bottom line at the expense of an equitable market and in particular, access to low-cost medical cannabis for patients like myself, which is a threat to their bottom line. And the primary mechanism of that regulatory capture is what has been talked about so much today, which is the revolving door. Obviously, this problem is far more acute in terms of things like Defense Department procurement contracts, but the manifestations in the context of the regulated medical and adult use cannabis industry in Maine are no less insidious. And in fact, I would say that absent these kind of guardrails, the giant corporate companies worth $11 billion or more very much will utilize their relationships and their lobbying power to put out of business the 5,000 local mom and pop caregiver operations that are currently helping patients like myself, helping the state of Maine thrive, and also really sustaining an authentic cannabis industry unlike anywhere else in the United States. So this bill could single-handedly facilitate the survival of that medical cannabis industry, and I really applaud the committee for taking it up, and I hope that you all will vote ought to pass. Thank you, Mr. Chair.
Thank you, Mr. Ellis, for your testimony. Questions from the committee for Mr. Ellis? Seeing none, thank you, sir.
Thank you.
Okay, next up we have Jennifer Bergeron. She'll be followed by Derek Short. Welcome, Jennifer.
Thank you, Senator Lucchini and members of the VLA committee. And I'm sorry, I'm a little distracted because I'm actually being called also for testimony in another meeting that's going on simultaneously. So I'll be very fast. I hope you vote ought to pass on this bill. It strengthens the integrity and protects this industry against the appearance of impropriety when you make sure that people aren't jumping from a job where they're representing one interest and then suddenly and instantly going to the being paid by the exact opposite industry. So I believe you've heard a lot of the details already of why this bill has been proposed, and so I won't get into those details. As I said, I'm being called in another direction. So thank you for your time.
Great. Thank you, Ms. Bergeron. It's that time of year where we have to be in a couple committees at once. Any questions? Yeah. All right. Seeing none, thank you, and good luck in your other hearing.
Thank you. Bye-bye.
Yep. So next up on our list, I believe it's the last in support, is Mr. Short. Now, Mr. Short, did you intend to testify on this bill? I think we'd had, okay, there's two bills with a similar title, so I think you'd signed up on the other, but you're good. I assumed this was the one.
Thank you.
Yeah, welcome.
Hi, thank you, Senator Keeney, Representative Piazzo, and everybody in the VLA. My name is Derek Short. I have a 5-year-old autistic child that uses cannabis every day to keep pain levels down, to keep focus up. He goes to school at Woodford's, and they are seeing amazing results from him using cannabis. We've tried other forms of medicine from doctors that just don't work. The cannabis crosses that blood-brain barrier and takes down inflammation in his brain and his spinal column. So that being said, I think we really need to cut back on the conflicts of interest in regards to our rulemaking process. There's obvious moves being made against Maine people in regards to the rules that are coming out right now. As Dawson and other people have said, there's been a couple people in the past that have used their position in the OMP to set themselves up nicely for other places to work. We need to, I think, weed out some of these people, down there that are making moves for their own personal gain and not looking out for Mainers. And I think this bill will actually help in that fashion. I know, looking at it right now, the people that are involved in our rulemaking process have done the same thing in Washington State and destroyed their industry. The medical program is gone. And they allowed everybody that wanted to grow, and only 22 stores to sell to, which made a huge surplus. And it drove the prices of per pound from 2,000 down to 300 and put everybody out of business, medical and adult use. So if we continue to have moves being made by these big companies to wipe out everybody and then come back and reestablish their dominance, I think we really need to limit that and look out for the Mainers. Thank you for your time.
Thank you, Mr. Short. Any questions from the committee at this time? Seeing none, thank you for your testimony.
Thank you. Have a good day.
Okay, that concludes the people who are signed up to testify in support. So next we will go to the opposition category, and we'll recognize Brina Bissell from DAFS.
Good morning. This is Brina. Are you waiting for me? It cuts out, so I didn't hear. I'm sorry.
Yeah, apologies. Yeah, we can hear you, but we can't see you, Ms. Bissell. But
okay.
You can, yep, you're up.
I'm going to turn my camera on. Thank you.
But the floor is yours when you're ready. Yep, welcome.
Good morning. So good morning, Senator Lucchini and Representative Chiazzo and members of the Committee on Veterans and Legal Affairs. I am Brina Bissell. I'm the Director of Maine's Bureau of Human Resources, and I'm here today on behalf of the administration to testify in opposition to LD 656. LD 656 would prohibit an employee of Maine's Office of Marijuana Policy from working for any entity requiring a marijuana license or registration within 24 months of being employed by the Office of Maine's Office of Marijuana Policy. The bill would also prohibit an employee of Maine's Office of Marijuana Policy from working as a lobbyist or lobbyist associate during that same 24-month period. Notably, as written, the 24-month lobbying prohibition does not appear to be limited to lobbying related to marijuana. Rather, it appears to prohibit such former employees from engaging in lobbying activities whatsoever. I believe the current laws strike the proper balance between protecting the integrity of the executive branch and not placing overly broad limitations on the right of former executive branch employees to be employed after leaving state service. I'm going to describe some of those laws, but I would recommend a careful review of the actual text of these laws because it's difficult to describe them in a comprehensive way. So 5 MRS Section 18 prohibits an executive employee from participating in the employee's official capacity in the legislative process or participating in any proceeding if the employee, the employee's family, partners, recent former partners, or professional stakeholders, organizations in which the employee is financially interested, or any person or organization with which the employee is negotiating or agreed to an arrangement concerning prospective employment has a direct and substantial interest in the matter. 5 MRS Section 18 also restricts a former employee's ability within 1 year after the termination of employment to act as an attorney, agent, or appear before the employee's former agency on certain matters that had been within the employee's responsibility more than 12 months prior to the termination of employment. And when such matter was before the agency within the 12 months immediately preceding the termination of employment, the former employee is prohibited from ever doing so. In addition to the above provisions, currently 3 MRS Section 318A prohibits any person employed within the last 12 months in an appointed position for which the governor can adjust the salary or a major policy influencing position from being a lobbyist or a lobbyist associate. In addition, 5 MRS Section 18A prohibits any executive employee from having a financial interest or receiving any benefit directly or indirectly from any contracts made on behalf of the state. Current laws strike the appropriate balance between protecting the integrity of state government while not unduly restricting future employment opportunities for state employees. Employees of Maine's Office of Marijuana Policy should not be subjected to greater restrictions on their future employment opportunities than all other similarly situated state employees. Placing excessive restrictions on the future employment of executive branch employees could adversely affect the state's ability to attract talented individuals to public service employment. For all the reasons above, we respectfully urge you to give LD 656 an ought not to pass report out of committee. Thank you.
Thank you, Ms. Bissell. Any questions from the committee? Chairman Chiazzo.
Thank you, Mr. Chairman, and thanks, Ms. Bissell, for your testimony. Do you foresee any concerns or any issues with the focused enforcement of this for just OMP versus any of the other state departments within the state or anything along those lines?
As testified, we do think the current laws that are in place for everyone are appropriate and address the issue. And so it would be concerning to have one group singled out. It may impact the ability to recruit and retain talent in that area. Yes.
Thank you. Any other questions for Ms. Bissell? All right, seeing none, thank you for your testimony. Now, I think that concludes anybody testifying against the bill. We'll move on to neither for nor against, and I will bring in Hannah King. She's First to testify, neither for nor against. All right, Ms. King, whenever you're ready.
Thank you. Good morning, Senator Lucchini, Representative Casio, and members of the Committee on Veterans and Legal Affairs. My name is Hannah King. I am a partner at the law firm of Drummond Woodsum, and I'm the founder and chair of the firm's regulated substances practice. In my capacity at Drummond Woodsum, I represent over 350 cannabis businesses. I also advise investors, financial institutions, accounting firms, municipalities, and tribal nations on issues related to the marijuana industry, both in Maine and across the country. I've represented stakeholders before the Marijuana Legalization Implementation Committee, in the Health and Human Services Committee, and before this committee when it took up marijuana issues for the first time last year. I was appointed to the Marijuana Advisory Commission by Speaker of the House, Sarah Gideon, as a representative of the adult use marijuana industry. That appointment was made based on a referral from former Senator Roger Cates and Representative Teresa Peirce, who were the chairs of the Marijuana Implementation Committee. That appointment was recently renewed by Speaker of the House, Ryan Fecta. I'm here today on behalf of Maine Organic Therapy and Remedy Compassion Center, 2 of the 8 registered medical marijuana dispensaries in the state of Maine, and Cureleaf, Maine, which has pending adult use marijuana licenses. Their operations and prospective operations are located in Biddeford, Auburn, Ellsworth, South Portland, Wells, and Bangor, communities which many of you represent. Once fully operational, their investment in these locations will be around $30 million. They currently employ 75 Maine residents in positions ranging from administrators such as Director of Human Resources, Director of Operations, and President, all Maine residents, to employees running the day-to-day operations. These are good paying jobs with benefits. Cureleaf, Maine anticipates employing an additional 75 Maine residents once its adult use licenses are operational. So we are here today to testify neither for nor against LD 656, but want to raise a point that's been raised several times, in that it does not appear to be that there are any similar prohibitions on employees of other regulatory agencies. For example, Department of Fish and Wildlife, Department of Agriculture, Department of other employees within the Department of Administrative and Financial Services, such as employees who regulate liquor or the gaming industry. It is unclear why it might be necessary to treat employees of the Office of Marijuana Policy differently than employees of other regulatory agencies. And further, there already is a prohibition on employees of the Office of Marijuana Policy from owning or being employed by a medical program registrant or an adult use program licensee. There have been some serious allegations lobbied against some former directors of the Department of Health and Human Services, and I encourage you to take these with a grain of salt. It is important that to the extent you're making decisions to target an individual agency, that those decisions are based on accurate information. And in fact, since the Office of Marijuana Policy was formed in 2019, no member of that office has left. In addition, just quickly to end, in all of my interactions with the Office of Marijuana Policy, I have found them, for all of my clients, all 350 of my clients, I have found them to be fair and transparent and to work with my smallest clients and my largest clients in the same way. And so I appreciate your time today and your consideration on this matter.
Thank you, Ms. King. Any questions from the committee? Representative Wood.
Thank you, Mr. Chair. Hi, Ms. King. I just wanted to double check that Cureleaf, they don't have any of the medical marijuana dispensaries. They're just in the waiting to get their license for adult use?
Yes. They are, so Cureleaf is a national company. I'm sorry, Cureleaf Holdings is a national company. It's based out of Boston. Its corporate office actually employs several Mainers. It has applications pending for multiple adult use marijuana licenses.
Okay, I've heard their name a lot, and I made an assumption somewhere that they were one of the medical marijuana dispensaries, and so I'm glad to make sure I have my facts straight.
Yeah, Maine Organic Therapy and Remedy Compassion are the two of the 8 dispensaries.
Okay, thank you.
Thank you, Representative Wood. Any other questions for Ms. King? All right, seeing none. Thank you, Ms. King, for your testimony.
Thank you so much.
That concludes our sign-up lists for LD 656. I don't think anybody else is in the attendee list that signed up late. If so, please raise your hand real quick and we'll recognize you. All right, seeing none, we will close the public hearing on LD 656. And Senator Lucchini's back, so before we get too far into it, I will turn the gavel back over to him.
Thank you, Mr. Chair. So I guess the final bill hearing of the day is LD 664. So we'll again bring in Representative Collings. So it's LD 664, an act to strengthen the integrity of the Maine Clean Election Program. Welcome, Representative Collings. The floor is yours for LD 664.
Thank you, Senator Lucchini, Representative Caiazzo, distinguished members of the Veteran and Legal Affairs Committee. I'm Representative Benjamin Collings. I represent House District 42, which is part of Portland. This is my second and final bill presentation for you today. I think it's the 4th or 5th of the year, and I'm sure if I have any more, Senator Farron will tell me I've reached my quota. So this bill—
no, you'll have to bring us a gift, Ben.
Yes.
Yes.
Yep. I will.
Yeah.
LD 664 is an act to strengthen the integrity of the Maine Clean Elections Program, and I'll try to be very succinct here on this one. So basically, after the past 2020 election cycle, some people reached out to me with a concern about an incident or incidences where someone running for office who didn't ultimately win a seat in the legislature or the Senate was trying to qualify for the Clean Elections Program. In the process of doing so, may have broken rules by whether it would be having other people falsify signatures or pay people to contribute $5 contributions. That had happened possibly, and in the process of doing so, before it could go any further, evidently the person had switched from being a clean election candidate to a traditional candidate, and there was no the investigation. I'm not sure how far it went, if it did go anywhere with ethics or the Maine Attorney General's office. It didn't reach fruition and went away. And so it was a concern brought to me. It was brought also to a former incumbent in the legislature who didn't win their seat. They were going to propose this law. They didn't win their seat. So I was asked to bring this to your attention. I have spoken to staff at the Maine Ethics. I've had some productive talks with them about this. And I think they're going to speak later more about certain instances. And they, I believe, say that what I'm trying to do may already exist in law. My intention of bringing this forward in good faith was that if somebody is running for clean elections using our tax dollars, that there shouldn't be any mechanism where if they somehow break the law with clean elections, they can't wash their hands clean by simply switching to being a traditional candidate. If that happens, there should be some matter that's taken up and shouldn't go away by them switching their designation as running for office. So that was the intent of the bill. I wanted to make sure the clean elections staff had all the tools possible to enforce if someone tried to, just take a turn to a different direction if they were caught breaking the laws of our election program. So that was the intent. Others are going to speak more about this. And if some people I know have contacted me saying that this might be a, may not be relevant because this already exists. I don't know if to the letter of the law, if the clean election staff has all the tools necessary to deal with cases like this. If they do, then that's a different story. And but the reason I brought this forward was there was a genuine concern from members of the public and former legislators of different parties about this matter. And I just wanted to simply bring it forward for your consideration to make sure that the legislature is providing all the tools possible that the clean election staff can enforce if people try to circumvent the laws. So thank you very much. I'd be happy to answer any questions. And I'm sure people from Clean Elections or the Attorney General's office, if they're to testify, could dive deeper into the specifics of their policies. Thank you.
Thank you. Representative Corey.
Thank you, Mr. Chair. Thank you for being here, Representative Collings. I think you could have pretended it wasn't you. I think last week you were sporting a mustache in front of this committee, so you could be in disguise.
Yeah. I did shave and I did find my glasses, and I'm trying to make people forget that my last testimony was like 15 minutes. So I want to.
Yes, well, it's a very good disguise. So my understanding is that a few years back they did prosecute somebody, and I think that there was even a little bit of jail time involved, and it sounds like you've had some conversations, and I think that there's it's very good nature to this bill. My only concern or my question is that do we leave room in here for discretion by the Ethics Commission, or even our Attorney General? Is there prosecutorial discretion within this bill?
Yeah, I mean, I don't want to be meddling or micromanaging programs that already work, or I should say policies that already work. And I would say that I kind of, having spoken to some people in the legislature and to the staff that oversees this program, I said I would just, while I was, this was in the drafting, I was getting feedback if this was necessary, and people kind of said, maybe let it go forward. And if we see something that, if we catch something beforehand, we'll let you know. And just right before the this hearing, I did hear back from some staff that after, looking through this, that they felt that while it was a good intention of mine, that they themselves feel that there already is policies that exist to deal with this, and they have been dealt with in the past. I'm not an expert in the letter of the law here. All I wanted to do was be responsive to people in Maine who brought concerns, and I support the staff, I support the program, and I have no issue with that. I just, if the need would be, if you see fit in this committee, or if the staff sees fit that there's other ways that they could have tools to more strongly enforce this program, I'm all for that. But again, if I'm being duplicative, I don't want to waste anyone's time to that end. So,
Representative Tuttle.
Yes, Representative Collings, I'm like Representative Corey. I'm aware of where the previous situation was. Are you free? Can you tell us where the complaint where it came from presently, or can't you do that?
Well, I don't want to. Unless people happen to be testifying later, if people kind of contacted me anonymously. I believe it was somewhere around in Penobscot County, and I don't have all the details of it. I just was by reliable people, including someone who formerly served here, and other people of various political parties, kind of had some concerns about this and brought it to my attention. So, but unless they're here, I don't want to express which individuals contacted me. So it wasn't anyone involved in this race specifically or had any access to Grant or whatnot. I think it was just overall kind of like a watchdog situation where people asked me if I knew about it, would I bring this forward? So.
Well, I'd agree with that, Ben. I think if the Ethics Commission does testify, that maybe they might provide us with that information. That I know in the past that if we had a representative appear before a committee on a number of occasions, we'd make them an ad hoc member of this committee. So Ben, I'm designating you as the new ad hoc member of this Committee on Legal or Veterans and Legal Affairs now.
Thank you, sir.
Chairman Chiazzo.
Thank you, Mr. Chair. And thank you, Representative Collins. I just want to make sure I understood you correctly. It sounds like if we hear from Director Wayne, who I think is on deck to testify, if he's comfortable with existing rules or statutes in place, that you're okay with us disposing of this and not moving forward with this bill. Is that fair?
I would say that if you hear the evidence as a committee that and using your discretion, that I'm not going to make this like a fight or anything. So if the committee sees fit that the evidence they hear is satisfactory, then I don't want to prolong this issue. It was something that very good intentions, and if you feel that they already have adequate tools to deal with this, then I don't want to tie this up and trying to get into technicalities or whatnot. I just wanted to make sure that indeed that these matters can be dealt with, and no one can avoid breaking a law by shifting their designation as a candidate. So thank you, Representative.
No, I appreciate that, Representative. That's very helpful.
Thanks. Any other question for the bill's sponsor? Seeing none, thank you for your testimony. Next, so I guess at this point, we'll move to the people who have signed up for, I think there's been a little bit of overlap with a couple of bills today. Okay, so there is nobody for or against. We'll move to Director Wayne for neither for nor against testimony, and he'll be followed by Allison Smith for neither for nor against testimony. Welcome, Director Wayne.
Thank you very much. Good morning, Senator Lucchini, Representative Chiazzo, and distinguished members of the committee. I'm Jonathan Wayne, the director of the staff of the Ethics Commission. And we appreciate the chance to testify and the concern of the sponsor over this. So I'm going to lay out in my written testimony and my remarks real quickly here what our current procedures are if we are concerned about a fraudulent situation. As all of you know, candidates qualify to receive Maine Clean Election Act funds by turning in qualifying contributions of $5 to us, along with required documentation that they went about collecting it the right way. And as far as, well, and let me just say that we receive more than 30,000 QCs every election year just from the legislative candidates alone. And we've got 2 employees, Aaron Gordon and Emma Berg, who do a very, very thorough and diligent job reviewing all of those qualifying contributions. And Aaron and Emma are very alert to the potential for fraud, and they are looking as much as they can, given that volume, for someone who's gone about not qualifying the right way. But as far as we can tell, in the qualification process for Maine Clean Election Act funds, fraud is very, very rare. We think most candidates want to go about doing it the right way. So it does not happen every election year. But if our staff here sees evidence that someone has, either a candidate or volunteer, has falsely claimed that they collected a $5 qualifying contribution from someone when they did not really receive the money from that person they're naming as a contributor, in order to allow that person into the candidate receive the Maine Clean Election Act funding, we have to verify whether or not fraud occurred. That's under current law. So we are really directed under current law to do an investigation at the staff level, and that's what we do. We send out questionnaires to the people who are listed as the contributors. We try to contact them by phone. Sometimes that's a complicated process because people have unlisted numbers and not everyone wants to talk to us and cooperate in the investigation. But we do our best to figure out whether the people really have given the $5 as indicated by the candidate or the volunteer who signed the forms. So if we determine that there was a situation where the candidate or a volunteer helping a candidate has falsely indicated that they collected $5, we we are very likely to refer them to the Attorney General. I conferred with our staff here, and this has only happened a handful of times where either a candidate for the legislature or someone helping out a candidate for governor, we've confirmed through our investigation that we think they falsely claimed they collected the $5. But when that happens, we are very likely to refer to them to the AG, and we cannot think of a single counterexample where we did not. I think the bottom line is that we believe we have the correct tools. We take this very seriously. We don't think there's any additional authority that is necessary. And I've referred to sort of the legal requirements on us and our procedures in my written testimony. And then I think my last 2 points very quickly, because I see I'm running out of time, are if we see that level of malfeasance, it doesn't matter to us that the candidate has withdrawn from trying to be a Maine Clean Election Act candidate or even withdrawn as being a candidate. We will still refer them to the Attorney General's office. And then finally, I endorse what Representative Corey said earlier about state departments needing agency discretion on whether or not they refer matters to the AG. This departments of state government should have that discretion. Thank you very much for the opportunity to testify. I'd be happy to answer any questions you have.
Thank you, Director Wayne, for testifying. And just, I guess, to be clear, if you start as a clean election candidate and switch to something else, there's no way that it just automatically makes it a clean slate, as kind of was suggested earlier.
Right. If they've turned in the paperwork to us that contains false statements about trying to collect stating falsely that they collected the $5 from people, we think that's serious. To make those kinds of false statements in an effort to qualify for Maine Clean Election Act funding, it doesn't make any difference if they say, oh no, never mind. So I'm not sure of the specifics of the case the representative has in mind, because I thought he was talking about one case, maybe he was talking about another case. He actually didn't feel, I guess, at liberty to identify who it was. So even so, I wouldn't want to talk about it in public. If you'll bear with me on that. But so I can't comment on the specifics, but it wouldn't make a difference if we confirmed that they said we'll just be a traditional candidate.
Right. Yeah. Thank you. Yeah, I think that's the important part. Representative Tuttle.
Yes, John, I know that Senator Lucchini was going to ask the same question that I was, but you really wouldn't feel free to give information that if it occurred this time, you wouldn't feel comfortable doing that. Is that correct?
You mean in this forum in front of the committee? Well,
had it occurred this election period, to your knowledge, something like this?
Well, it doesn't happen every year. The sponsor made reference to some case involving the 2020 elections.
Right. Penobscot County, you mentioned, John.
Yeah, I don't want to talk.
I think and sorry, Director, but I think it's probably good we don't speculate on things, Representative, based on rumor and things, unless there was like an official filing or something or ruling. And Director, I'm sorry to cut you off.
It's okay. Thank you.
Well, Mr. Chairman, you have corrected me again. Thank you.
I'm not trying to correct you. No, that was not my intention. Representative Wood.
Thank you, Mr. Chair. Mr. Wayne, I just wanted a little refresher as a first-time clean election candidate. At the time, I think I had the fear of God put into me to make sure I didn't do anything wrong and that everything would be checked, and I felt like it was, and I felt that your staff was very helpful in helping me make sure that I understood exactly what needed to be done. My question is just a scenario. If I was out collecting $5 for clean elections and then it became apparent that I didn't think I was going to make it by the deadline and I needed to switch to become a traditional candidate, all the QCs that I collected would have to be returned, correct?
We'd leave it up to you. You could either return them to the people who gave them the $5 to you, or if you wanted to just give them to the state of Maine. As sort of a gift to this program, we would deposit them into the special revenue account from which we pay the candidates. You could go either direction.
But I couldn't keep the $5 to then just sort of convert it over to my traditional campaign.
I mean, no, you couldn't do that. And it would be, practically speaking, a little difficult because all the payments are made out to the Maine Clean Election Fund. They're made out to the state account. So it wouldn't be an easy thing to do, but that's not really something that we would recommend either.
Okay. Well, I just think now with there is cash that's allowed. And so that does make it, you know, a little funkier, if you will. I mean, the ones that are done online with credit cards, I mean, that you wouldn't be able to change, but I couldn't remember exactly how all of that worked.
Well, you know, to be honest, I think this might be addressed in statute, and rather than have you wait while I flip through the statute, I know for a fact we recommend one of the other two directions. Either you give them to us to deposit as a gift to the fund, or you return them. And I know that would be consistent with what's in the statute, but I'm sure just sort of keeping it as the candidate is not consistent with the statute.
Okay. All right. Thank you.
Yeah.
Okay, Representative Corey.
Thank you, Mr. Chair. While we're on this, I had another kind of question similar to hers. The one that always, having been a clean election candidate in the past, the one that always kind of drives me bonkers is like, well, I'll tell you sort of like my fear at first when I first saw this was that, you know, I might have a constituent go in and give multiple donations to me. Do you know what I mean? Based on, you know, those $5, do you know what I mean? Online, you know, contributions. And I'm like, I don't want them to think I solicited another one to hit my, you know what I mean? Get up my number or anything like that. The side issue there is really that, you know, people are giving the Ethics Commission more money thinking they're helping a candidate out. And I think that's reflective of, you know, the $5 that they're giving. Is there a way that we could make it so that once they've given one $5 contribution with their name, address, you know, and everything else, that the thing just stops accepting contributions from that individual? Because I think I've seen instances where I think somebody even gave me 3. I know there's definitely a number that have given me 2, but, you know, I don't think it's clear to people that they shouldn't be donating more than once.
Yeah, we will, if we see part of our review of the online QCs as we look for duplicates. In fact, we look for duplicates overall. So if somebody gives you a check and an online QC, we see that as well. And we will catch that and make sure that that person is only counted once. We could absolutely look into that. And I just would want to make sure it doesn't make the process any more complicated for people to get like a little pop-up box, like, oh, it looks like you've given before. We could look into that. I just want to make sure it doesn't add any complexity to the system.
Oh, it's sure to add complexity to the system. I was just wondering if it's something we could do. Thank you.
I mean, I assume we've thought about it before, and I'm not sure why we didn't go down that road. That's the only reason I'm hesitating and signing on to the idea. Yeah.
Great, thank you. Any other questions at this time? Seeing none, thank you, Director Wayne.
Yeah.
Yep. So at this point, I believe we have one more person registered to testify. If Allison Smith is in and able to hear us, you have the floor.
Hi.
Oh, welcome.
Good morning. Can you hear me?
Yes. Yep.
Great. Thank you so much for the opportunity to speak. Let me just bring up my testimony here. I am Allison Smith. I'm a resident of Portland. I'm here today as a volunteer on behalf of Maine Citizens for Clean Elections. I appreciate Senator Lucchini and Representative Chiazzo for the opportunity to speak, and I want to give a shout out to my own rep, Barb Wood. Nice to see you. So Maine Citizens for Clean Elections has been advocating for clean elections for more than 25 years. We were there at the beginning, and we have been there throughout, advocating for the strongest system possible and help trying to push back any threats that weaken it. So we could not agree with the sponsor more that the integrity of the Clean Election Program is critical to its long-term success. We've supported many tweaks to the law and the rules over the years in order to make the system more accountable and work better. And if we thought this bill was aimed squarely at a problem that required a legislative solution, we would be the first to support it. In this case, we don't see the problem that the bill attempts to solve. What we see is the Ethics Commission staff does scrutinize qualifying contributions. And if something is off, they do dig deeper, as Commissioner Wayne explained. There's nothing stopping them from referring cases to the Attorney General as they see fit, and we believe they are in the best position to determine when that action is necessary. So the current law neither holds the Commission back from full enforcement, nor does it force dramatic action when such a response may be inappropriate or unnecessary. And that seems right to us. It seems like it works pretty well. Finally, just in general, we're kind of skeptical that asking for mandatory referrals, it just seems like a blunt instrument to the problem when what you really want is excellent enforcement of this law, just like for any other law. So we think it's far more important to just make sure every year that the Commission has the tools they need and the capacity to pursue every instance of noncompliance, and also that they operate with the transparency that would allow, folks to determine whether that was happening. So we're confident that if they have what they need to do their jobs, they'll continue to refer cases appropriately to the Attorney General. But the idea of the mandatory referrals, it just seems like if you have a problem that you're kind of kicking down the road. We have always appreciated the way the Ethics Commission operates and the appropriate use of discretion in enforcement matters, and are confident that, barring evidence that hasn't yet been shown that this bill
Okay, I can't tell if has Miss Smith broken out, frozen for everybody? Okay, Ms. Smith, I think your computer has frozen right as the clock was expiring.
I think it was Chairman Chiazzo's clock that caused it too.
He's got new powers now.
Well, he's guilty, Pat.
That's a pretty amazing cell phone you have, Chris.
Okay, well, apologies to Ms. Smith. We have some technical issues, but thank you if you can hear us for your testimony today. Oh, and looks like she's dropped now. Okay. So with that is all that we have for people signed up to testify on this bill. So I will close the public hearing on LD 664. Okay. Chairman Chiazzo.
Thank you, Mr. Chair. I'm going to do my best Representative Tuttle impersonation. Mr. Chair, if it's appropriate now, I would suggest maybe we move to go into work session on 624 or 664, excuse me, LD 664.
Second. Sure, yeah, the timing is right. So there's a motion to go straight to work session on LD 664 by Representative Chiazzo and seconded by Representative McCrate, I believe, right? Okay, any discussion on the motion to go to work session? Seeing none, we'll proceed to a roll call vote. If you're available, Karen. Yeah, thanks.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, could you put your camera on too, please?
Oh. Senator Hickman, are you available?
We can come back to him.
Okay, we can come back. Yeah.
Right. Senator Farron.
Yes.
Senator Farron, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolph.
Yes.
Representative Dolph, yes. And Senator Hickman, are you there? Senator Hickman, absent. So 12 in favor of the motion, 0 against, and 1 absent, Mr. Chair.
Okay, 12-0 of those present. We will go straight to work session. Senator Farron.
Based upon the testimony we heard from Director Wayne and the questions that the chairs asked of the bill sponsor, and seeing how the bill sponsor called out, about my support of his bills, I'm going to make a motion of ought not to pass.
Second.
Okay, a motion of ought not to pass by Senator Farron, seconded by Chairman Chiazzo. Sorry. Is there any further discussion? Seeing no discussion at this time, we can proceed to a roll call. And again, the motion is ought not to pass.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, we can come back. Senator Farron.
Yes.
Senator Farron, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Sorry, my earbud fell out. My apologies. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolph.
Yes.
Representative Dolph, yes. Senator Hickman. Senator Hickman, absent. 12 in favor, 0 against, and 1 member absent, Mr. Chair.
Thank you, Karen. So the vote is 12-0, unanimous of those present of ought not to pass. Okay, so we'll close the work session on LD 664. It was a number. Should probably double check that. Yeah, 664. Okay. With that, I believe that concludes our work for today. Is that right, Janet? Yep. Okay. So we'll be back on Wednesday morning with public hearings beginning at 10 a.m. And then this is another week where we have to pick up a Friday, I believe, where we have some confirmation hearings. We got several confirmation hearings and potentially some work sessions. So we'll send the schedule out, but Friday we will meet for confirmation hearings. So, all right. Is there anything else? Are we good to go? All right. Well, thank you, everybody. We will adjourn for the day. Thanks.